with us for this one-day seminar on FEMA. It's my privilege to begin the program. It's a 4 technical sessions and 1 panel discussion. I request the panelists and moderator to come to the dais and talk to the seats. It's my privilege to welcome the moderators and panelists. It's my privilege to introduce the moderator and panelists for this session. First, we have CA Suchint, and he is a partner in Deloitte Haskins, specializing in international tax and transfer pricing. He has over 2 decades of tax and transfer pricing experience, specifically in the areas of conceptualizing transfer pricing solutions, value chain structuring, audit defense, dispute prevention and resolution, advisory assignments. He is a member of Global Capability Center core team that engages, incubate and scale tax and business processes in multinational organizations. With this brief introduction, I present you before CA Suchint. Second panelist, we have CA Aditya. He is a partner in PwC, deals practice and specializes in M&A. He has around 2 decades of professional experience in tax and regulatory structures and consulting advisory related to multinational corporates and domestic clients. As part of M&A team, Aditya has gained vast experience in consulting, strategizing, evaluating, structuring and implementing various M&A transactions, cross-border restructuring, foreign investments, structuring, tax due diligence, buybacks, financial restructuring, corporatization and other transactions for leading Indian and multinational companies. With this, I present for you CA Aditya. After that, third panelist is CA Lalith Shukla. He is a chartered accountant and company secretary with over 35 years of experience in compliance management, corporate finance, planning and structuring, merger and acquisition, commercial negotiation in various companies ranging from software development, IT-enabled services, shared F&A services, manufacturing, commodity trading and engineering consultancy. Presently associated with Pilot Services Private Limited as a specialist for compliance transitions and specialized engagements since May 2012. Prior to Pilot Services, he has been employed with MindLogix, Uroka, Safran Aerospace, JNT Group and various other companies as head CFO, head finance and company. With this brief introduction, I present before you CA Lalith Shukla. The 4th panelist for the day, CA and also advocate Chidanand Urs. Chidanand Urs is a fellow member of Institute of Accountants of India. He is now practicing as a lawyer. He has completed his law from Bangalore Institute. He is a practicing lawyer for the last 25 years. He had practiced as a chartered accountant initially for 6 years before changing his profession to advocacy. He is representing matters in the areas of central excise, customs, service tax, and GST. He is also specializing in the field of foreign exchange management law, money laundering cases before various departmental authorities, tribunals, and courts. He is a co-author of a commentary on Foreign Exchange Management Act 1999. The first edition was published by Varpa and Company, Nagpur, titled Commentaries on FEMA. The second edition is now on stands published by LexisNexis. He is also a collaborating author on Guide to Central Excise Law and Practice by Arvind P. Datar and B. N. Gulraj for their earlier editions. With this brief introduction, I present before you Chidanand Urs. Our moderator and coordinator for this program, CA Vivek Mallya. He is a practicing chartered accountant born and raised in Bangalore. He is qualified as an US CPA and holds a master's degree from Mysore University. Prior to his practice, he has been partnered with Big Four firms as well as an AVP Finance, an Indian advisory board in large MNC. Vivek currently consults mainly on FEMA, income tax, international tax, and also an insolvency restriction professional. He is currently an independent director on the board of ONGC Tripura Power Corporation Limited a natural gas-based power plant with India's best plant load factor and power factor to the 7 Northeast state. Vivek has also been independent director on boards of Oil and Natural Gas Corporation Limited and Mangalore Refineries and Petrochemicals Limited, earning status as one of India's youngest board members in PSUs. Vivek has also been national president on Keshwa Seva Samiti, a Bangalore-based NGO, and his country is trustee. Vivek has trained GST officers in Karnataka, banking and insurance as a visiting faculty at Fiscal Policy Institute of GOK and has been a BOS member of Linga WE School, Bela. With this brief introduction, I am present before you the moderator and coordinator for the program, Vivek Mallya. It's time to lighting of the lamp. I request all the panelists and moderator to join us to lighting the lamp.
Sutteshu jagrati, Yaesha Sutteshu jagrati, Kam 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 Ushalo Nirvimana Aditya Shukla
I request the moderator, CA Vivek Mallya, I request moderator CA Vivek Mallya to start over the day.
Good morning, everyone. And welcome to this Monday session of Context Management. For the first panel discussion, we have 4 distinguished speakers, all of them with experience in FEMA and have practiced in mergers and acquisitions, deals, transactions, also on the advocacy and litigation side. Without much ado, let's start the proceedings with CA and Advocate Chidanand Urs. I say CA more fondly than advocate. So the members of the institute are here today, and Chidanand has been an outstanding member of the institute and now practices in the High Court of Karnataka as well on litigation. He has some very famous public interest litigations against his name, including the reinstatement of local Ayuktha in the state of Karnataka. His public interest litigation led to reinstatement of local Ayuktha in Karnataka. So it's very interesting to be here if you're interested in advocacy. So without much ado, sir, my first request to you is for a brief overview of
any mantra actually not mantra. Because I only do litigation side of practice. I have never been a part of procedures at all in my 25 years of practice. My picture is only when people get into trouble. So, before that, it's all the chartered accountants would be doing the bunch of the work, the procedure side of it, the planning side of it. Now I will come to the basic overview of foreign exchange management act. This act was devised in 2000, as you all know. There was a basic, tremendous shift, I would say, from Foreign Exchange Regulation Act of 1973 to Foreign Exchange Management Act. The preamble itself categorically states that there is no longer requirement of conserving foreign exchange. Now the impetus is on managing foreign exchange. There is complete difference. Foreign Exchange Regulation Act was a criminal law. Any violation would have entailed prosecution. But under the Foreign Exchange Management Act, it has more or less become a civil law. What would entail if there is a violation of the provisions of Act, rules, regulations, or even the master direction is that of penalty under Section 30. There is only one prosecution under Section 37A. I will come to that later. Now we have 49 sections under the Foreign Exchange Management Act. The most important, the first time the Foreign Exchange Management Act, Section 49(3) of the Act, which provided for a sunset clause. This was the first time it was conceived under any of the repeal and saving laws, where if there were to be any violation under the provisions of Foreign Exchange Regulation Act, the enforcement authorities have only got 2 years' time to start or commence the litigation or commence the proceeding for violation under the provisions of Foreign Exchange Regulation Act. FEMA came into existence on 1st of June 2000. On or before 31st of May 2002, any violation under the Foreign Exchange Regulation Act, the proceedings should have been initiated under that Act by the enforcement director. If the proceedings are not initiated under the provisions of Foreign Exchange Regulation Act, no jurisdiction exists when the enforcement directorate to commence the proceedings after 31st of May 2002. This is for the first time that a penal law was given a quietus after 2 years, that one, the department could not or cannot take cognizance of the law. The matter ends there. Nobody can be proceeded against that law. Now, there are 49 sections. The most important is from Section 1 to Section 9. The crux of Foreign Exchange Management Act is under Section 1 to Section 9. There was again a stark shift from the Foreign Exchange Regulation Act, which was transaction based. Now we have a categorization of the transactions into current account and capital account. All the transactions which have been undertaken have been broadly classified as a current account transaction or as a capital account transaction. Section 5 deals with current account transaction. Section 6 deals with the capital account transaction. The thumb rule is on a current account, because when we read the preamble of Foreign Exchange Management Act, it says this act is to facilitate trade and commerce and other current transactions. So it means that this act is now a facilitator for a current account transaction. So Section 5 says every transaction on the current account is free to be undertaken, but for the restriction which is being provided provided by the central government. As far as current account is concerned, now I think the distinction between governance by central government and state government is more or less merging, because the current account was regulated by the central government. Now even the capital account is regulated by the central government because Section 6(2), which overrides all the other regulations which have been notified by the Reserve Bank. Now central government is the authority which also regulates capital account transactions from 2019 onwards. So On a current account, the principle is that all transactions are free to be undertaken until and unless there is a restriction provided specifically by the rule. The rule has got three schedules specifically. First is absolutely prohibited transaction. Second schedule, which are the transactions where you will have to avail permission of the central government or the respective ministry to undertake those current account transactions. The third is the transaction which is permitted, but if you go beyond the permitted limits or whatever specified in the schedule, you will have to apply for the permission from the Reserve Bank. This is our current account. Only one rule for the current account, that is the current account rule, which is being notified by the central government. When it comes to capital account transactions, there are host of rules and regulations which are being notified. So the province of the act is very small. When it percolates down to the rule and regulation, it becomes very, very broad. And the scheme of the act, it is all administered by more or less by notification, not like the Income Tax Act where you get everything under the act. In case of foreign exchange management law, it is being administered more or less on a daily basis. You get APDR circulars on every month, changing the whatever is the condition, whatever changes the RBI want to make, it can do it, because the whole repository of the foreign exchange law is the Reserve Bank. Unfortunately, there is Vivek said that you have to give us what are the important decisions and recent developments in foreign exchange law. We have very less development in foreign exchange when it comes to either the High Court decisions or the Supreme Court decisions. For one reason, that Supreme Court recently in Akshay case, where the Supreme Court said that the Reserve Bank is the main agency. Supreme Court uses the word, they are an expert in foreign exchange law, and they said whatever Reserve Bank does and state and provides for, nobody can probably override whatever decisions are taken by the Reserve Bank in the interest of our country. And also, Supreme Court has said in Ashan Mehta and various cases where in economic legislation there is a big leeway given to the government to make any type of an amendment. You can't go and say it will impact my business, it will have difficulty for me to undertake certain transactions. Obviously not possible to take all these arguments before the court because it's an economic law, and Reserve Bank with a motive of developing the foreign exchange transactions in our country can impose any amount of restriction. Now I will come to the rules part over the regulation part. It is more or less, it will be now reduced to all the rules because whatever regulations are provided by the Reserve Bank of India under Section 6, which was notified. Now, those regulations are still in existence until such time that the central government either repeals it or resigns. So, as we see, the non-net rules was devised and ODI rules was devised by the Reserve Bank. Reserve Bank has taken the powers now, so rather the central government. Central government has taken the powers now to devise the major rules. Now the ODI rules are being devised by the central government. The FDI rules are being devised by the central government. It's very much the same, but the powers are invested with the central government now and no more with the Reserve Bank of India. There is two more lines of clarification which are issued by the Reserve Bank. All the transactions which are undertaken by us cannot be monitored by Reserve Bank. It always goes through the authorized dealer, authorized person, as we know. If we have to undertake a transaction, the first thing what we do is we go to the authorized person to effect those transactions under foreign exchange law. So these authorized persons are monitored, guided, and directions are issued to the authorized persons or authorized dealers by the Reserve Bank by way of an APDIR circular, and consolidation of the APDIR circular will happen by way of what is known as a master direction issued by the Reserve Bank of India. On a subject, master direction consolidate all the earlier APDIR circulars and put the thing in one place, and you would get and the master directions are also binding on the find a place anywhere, maybe in DPDS circular or wherever. Because you can't take an argument that master direction said something more than what is required to be told. No, because master directions also have a force of law which can be enforced through the authorized dealer. Section 11 clearly, 11 is the section which gives direction, or RBI gives direction to the authorized dealer. This is how the broad scheme of foreign exchange management law works. And now coming to the part of the litigation mechanism under the foreign exchange management law. Every violation under the foreign exchange management law is investigated by the enforcement directorate. The investigating authority is the enforcement directorate. Enforcement directorate has no other power other than investigation of violations under the foreign exchange management law. Any violation of act, rule, regulation, direction issued by the Reserve Bank is an offence where the penalty under section 13 is 3 times the money involved. If the situation so arises that there is a violation which is technical in nature, where the amount, the value involved or the money involved cannot be quantified, then section 13 says that the penalty is 2 lakh rupees maximum, and if there is a continuing offence, it says some 5,000 rupees or whatever the penalty under section 13. There is one more addition to section 13 in terms of section 37A. For the first time, FEMA, being a civil law, has inserted a prosecution mechanism. If in case a person owns foreign exchange, foreign security, or immovable property outside India in violation of section 4 of the Foreign Exchange Management Act, and the foreign exchange so held, or the foreign security so held, or the immovable property so held is more than 1 crore rupees, then the enforcement directorate will have powers to seize the value of that such foreign exchange from out of the assets of that person in India. Obviously, the seizure happens, and parallelly, the prosecution proceedings will also be commenced against that person. And if found guilty, the imprisonment can go up till 5 years. This is the only provision where somebody can be put behind bars for a violation under section 37A read with section 4. And there is a mechanism provided under the Act itself. If such person finds out, and if he says that yes, I have made a violation and the assets will be liquidated by me and I will liquidate your assets and bring it back into the country, then you can make an application either before the compounding authority or the adjudicating authority saying that I have brought back the asset, kindly pass an order in my favor or don't continue the proceeding, because the proceeding can abate, or if the officer feels that the proceeding has to be continued, he will still continue it. He has got options of passing an order either way. It is not that the moment you bring back the money, automatically all the proceedings will abate. It is not the case. It is again within the quasi-judicial jurisdiction of the adjudicating authority to either pass an order accepting whatever money you have brought back or not accepting it. The mechanism is this. Once the assets are seized in India, the enforcement directorate files a complaint before the joint director, which is the competent authority, who is from the government of India. He files an application saying that I have seized it. The competent authority confirms the seizure, or if there is enough evidence and if you are representing before the competent authority to show that there was no violation of section 4 and it is being seized wrongly, then he can set aside the order of seizure passed by the enforcement directorate. There is one more round of litigation in the same sequence. The compounding authority has got only powers to the proceedings for imposition of penalty. The penalty is 3 times the amount involved, and the adjudicating authority, after passing an order, if it feels that prosecution also is required to be proceeded against, he will file a complaint before the magistrate for prosecuting that person. So there are 3 streams of litigation which get started if somebody keeps assets outside the country without the tacit permission of the government or without following the requirement of Section 4. Section 4, what is read with Section 3, what does it say? If you have earned any foreign exchange or income or any asset outside India, when you are resident outside India, that can be still held by you. The problem arises when somebody does something illegal which is not permitted under the Act. That is the one which gets hit under Section 4, and all the consequences would fall. This is the only amendment which will be made for under the FEMA, which permits somebody to be prosecuted, somebody to be arrested. Otherwise, FEMA does not have the enforcement. I'll tell you with a lot of force that enforcement directorate does not have powers to file. When investigating under FEMA, when summons are issued, invariably when the person appears before the officer, they will be very harsh, whatever about it, extremely harsh. But they will also threaten saying that I will arrest you and they will get the statements recorded from such person. You all have to tell them only one thing, that if the statement is against his wishes that they have got it signed, you can always tell your client to retract the statement immediately. The retraction has to happen immediately. It can't happen after 1 week or 10 days. Then it will be considered as an afterthought. So, whoever you are advising, if the ED gets the statement recorded from you, contrary to whatever you have to say, you can always get the statement recorded and retracted. And it's always there because again, if you retract, they will come up with more of a vengeance probably, but it doesn't matter. Even if they come back and say, now you record the correct statement, whatever you want to say, you can give your statement. If you are not satisfied, still you can keep continuing to retract it. There is no hard and fast rule that only one retraction is possible, and always. And nowadays, the way the investigations are conducted by the ED, I would say that they are only going for the statement. They don't go for gathering any corroborative evidences at all. So you are safe one way. Supreme Court held that the proceedings under Foreign Exchange Management Act or confirmation of penalty or violation of law cannot happen only based on the statement recorded by a person. It has to be by way of corroborative evidence. They have to prove whatever statement has been given by me. There are some evidences to show that the statement given by you is correct. It cannot just be on the basis of the statement given by the person. So you can be quite sure tomorrow if you can lead evidence completely contrary to the statement given by the person, then it is well and good, because you can always say the statement was taken under duress. The statement was taken under coercion. This is the most important thing for because you will probably get quite a lot of summons for your client for all sorts of violations. And once you read the summons, you will probably know the reason why the summons are made. There are certain specific things which the officer asks. So you will be able to ascertain what is the violation which he is contemplating or where he is investigating. He would normally not tell you the nature of the investigation done. And whatever statements have been taken by the enforcement directorate from you, a copy of that need not be given. This is important. The copy will be given to you only when they issue a show cause notice. They issue a complaint. The complaint will go before the adjudicating authority. The adjudicating authority, if he is satisfied with the complaint, he will start with what is known as the inquiry under the Foreign Exchange Management Law. There he issues a show cause notice to you. when the show cause notice is issued, when he wants to rely on the statement, whatever has been given by you, he'll give a copy of the statement. If he is not relying on the statement given by you, he need not give a copy of the statement. And if there are documents which have been seized by the department or impounded during the search, you can always take copies of this document because you are well versed rather than me, because all the proceedings are under the foreign exchange law of seizure and the proceedings in investigation is under the income tax act. Whatever the seizure mechanism and the investigation mechanism provided under the income tax act is incorporated into the foreign exchange management act. I think I will exceed my time. If there is anything specific, I will get into it later. Because there's so many things to say, but time doesn't permit. So I'll conclude my short discussion. Thank you.
Sir, thank you very much. You make it sound so easy. How many of us have been to the Enforcement Director's office in Chandigarh? I'm assuming as an authorized representative, not as a respondent. So have you been to the Enforcement Director's office? Okay, sir has been. So it's a 3,000 square feet office, requiring a fingerprint to go in of the peon who may give it to you or go in. In the 3,000 square feet, there will be only one sofa, two-seater, and there are 5 cameras pointed at you, and you will be made to wait for another hour and a half before you give a statement.
Sir, no, my standard line is this: whoever goes to the enforcement directorate when they are summoned, I'll tell them to take a good novel or any other book. I've been telling my client, take one book, even though you don't know English or whichever language, you take one good book, keep reading through it, or pretend that you are reading through the book, because they are all watching. They are watching to find out how impatient that person is. If he is moving around, if they will make them wait much more. And they will never call you, they will only call you at 5:36, they will call you by 10:30. And if you are late by half an hour, one person will come and say, why are you late? And you say, no, okay, sit down. And they will only call you by 5:36. They will make you sit till 9 o'clock. All these are standard practices of the enforcement directorate, and you better inform your client that you will only be called by 6 o'clock. Till then, do whatever you want to do. You watch, you sleep. If you sleep, it's still better. Then in that peace. Under FEMA, if you are investigated under FEMA, you don't need to worry because he's not going to arrest. He's going to threaten you. There are instances which I should not say that they are got physical also. In such a situation, you can always file a police complaint. It depends on how forthright your client is, basically. So these things should not be done, but they do it as a tactic that's not something which is unknown or unheard or anything like that. And you will have to, but chart accountants cannot go with the client. An advocate can go, but he will make it sit outside, no point going. He will not be allowed inside. The rule is advocate will be sitting at a place where he can see his client, but he cannot hear what he is stating before the investigating officer. But we don't have that thing. There are small rooms which has been made like a thing in the office of PD Bangalore. So they will probably not allow you at all. So you can't fight. And one more thing is, even if I am an advocate arguing a matter, they will not allow my mobile to be taken. It's a very peculiar thing. Even though I go there to argue matters, I've been going many times. Now they allow because some of them know me there. So I said Supreme Court allows. Where is the restriction? Have I been going there to be investigated? They don't allow mobiles of anybody inside. Even if you are arguing a matter, they say keep your mobile out.
Thank you, sir. Now, coming back to more mundane and day-to-day things, I would request our panelist, Suchint Majmudar, partner Deloitte, to help us with income tax, transfer pricing and FEMA, the based on this experience, what are the interesting transactions or aspects which you want to share with us? Suchint Majmudar.
Good morning. It's a pleasure and privilege to speaking at the St. Augustine end. I think first of all, in context, it would be useful to, at a very basic level, understand and appreciate that foreign exchange management law is literally that. It's a law, it's a regulation, it's an economic legislation. And income tax is in fact fiscal legislation. And what that means is that the law is something where you have a yes, no, maybe. And I say the maybe because that's, let's say, subject to approvals. Whereas fiscal legislation entails a cost. There is very little yes or no, there's nothing impermissible or almost nothing impermissible. But each time you do something that is quote unquote a disallowance as it were, it entails a tax cost. So when we internalize this difference between income tax and it's useful to keep the law versus tax distinction in mind. Now, having said that, the aspect of there are certain aspects that are common between the economic legislation of FEMA and the fiscal legislation of FEMA. For example, the reference to current account and capital account transactions. For example, the synchronization, as it were, between a resident under the Income Tax Act and a resident under the foreign exchange law. And we get to that in another session. But the point being that, therefore, there are similarities. And it's useful to keep those similarities in mind because there are those parallels that would be applicable. But in particular, the distinction between capital and current account is useful because in the context of FEMA, everything that's a current account transaction, practically everything that's a current account transaction is prohibited. And therefore, whether it be remittances for goods or services, those are current account transactions that are prohibited. Capital account transactions are, for example, investment in and outside of India, are the ones that are subject to regulation. So therefore, that's to do with FEMA. But when it comes to income tax, the current account transactions and capital account transactions have different connotations. Current account transactions typically are income and expense, and therefore subject to deductions or being applicable to incomes, whether they be taxable or not taxable. And capital account transactions, such as capital expenditures, are the ones that normally don't get allowed. Coming to specific demands of related party transactions, there is, in respect of both fiscal as well as economic legislation, this applies to company law, this applies to customs, this applies to FEMA, this applies to income tax. There are transactions that happen between related parties, so in other words, associated enterprises. In the context of income tax, this borrows from the Model Convention, the OECD Model Convention, and the UN Model Convention, which then gets enshrined into treaties. Treaties are associated with income tax law, and they speak about associated enterprises. And what they speak about is that transactions with associated enterprises, in other words, related persons, need to be taking place at arm's length. At the core, even in the context of FEMA, while the expression fair market value is used, the equivalence between arm's length and fair market value is practically identical. And therefore, it's useful to note that whenever the context of related party transactions arises, and it's not only related party transactions in the context of FEMA. FEMA talks about resident to non-resident, and therefore speaks of fair market value as an equivalence in respect to any of those transactions. It's useful to keep in mind this interplay between arm's length price and fair market value. Now, we spoke about the fact that in or under income tax, you have current account transactions and capital account transactions, and that current account transactions, both income and expense in related party contexts, do need to be dealt with at the arm's length price. And this is the distinction between FEMA, which permits a free passage of current account transactions, but for the quote unquote baby transactions. Whereas in the context of income tax, every transaction that happens between related parties, whether it be current account or capital account, needs to be having to take place at arm's length. So therefore, this is an important distinction. You will also find this in company law, for example. You will also find this in customs, where transactions between related parties takes place. They become subject to special valuation branch in the context of customs law. In the context of company law, it becomes subject to section 188, which applies to related party transactions. So when you look at fiscal and economic legislations, there is necessarily valuation that plays an important role both in relation to current and capital account transactions. One instance of a case of interplay between foreign exchange law and income tax is with reference to external commercial borrowings. If you think of a bond has a foreign currency bond has about 3 or 4 variants that need to be considered, or variables that need to be considered. One is the price of the bond itself, which is subject to fluctuation if it was an open market instrument. The second is the interest rate. The third is the fact that it's subject to foreign currency fluctuation. And specifically in relation to income tax, there is also the application of the interest limitation rules. There's also a fifth one, which is to do with recapitalization, which means that would somebody have been so thinly capitalized as to keep the debt equity ratio in an extremely drastic proportion. So that's in fact even a fifth variable when you look at it in the context of external commercial borrowing. But speaking more specifically of external commercial borrowings and FEMA, the FEMA prescribes a certain number of basis points above the benchmark rate, and now after transition from LIBOR, there are benchmark rates that have been set up by currency. And so these benchmark rates speak of something around 500 to 550, and that's an all-in cost ceiling. It's important to remember that the all-in cost ceiling does not include withholding tax. So you have on the one hand an all-in cost ceiling, which means that that's the amount of outflow that can go to a non-resident on account of NCP. But when you look at income tax, the answers will be different. So let's take an example where the benchmark rate is, let's say, 500 points above the benchmark rate, and or the all-in cost ceiling is 500 points above the benchmark rate. You could have a case where you are in effect paying 500 and even 600. And I say 600 because let's say that the 100 basis points is towards withholding tax. Now that's permitted under FEMA because you're still within the all-in cost ceiling. But under income tax, let's say that you determine from the benchmarking analysis that the arm's length rate for the interest payout is, for instance, 350 basis points. 350 basis points above benchmark rate, and you effectively paid 600, so there's a 250 surplus. What happens with that 250 is that in effect that amount has to be offered to tax as income, or it is a disallowance as an expense. Whereas interest limitation too, which says that if you operate within a corridor of up to 30% of EBITDA, you are able to take the deduction. If your interest expense is greater than 30% of EBITDA to a non-resident associated enterprise, then that amount gets disallowed and again is allowed to be carried forward for a period of 8 years. So it almost becomes a deferred expenditure as it were. So therefore, again, it's essential to recognize that in the context of FEMA, outflows are triggered only with respect to what is actually paid out, not withholding tax. In the context of income tax, withholding tax is income earned, and therefore it has to be reckoned as part of the expenditure that is being claimed, and that is again subject to interest limitation rules. I think the other thing is that there are, when we deal with most aspects under FEMA, where we deal with fair market value. Fair market value applies, let's say, in the context of simplistically speaking, to shares of a company. And there you tend to apply the discounted cash flow method, which is one of the accepted valuation methods. Again, remember, both FEMA and income tax are flexible in the sense that they both contemplate any method that is internationally recognized. And therefore, while DCF is often resorted to, you could also have cases where you could use comparable transaction methods. But when we speak of DCF, again, remember that the point is that there are, for example, the uncertainty of cash flow, the discount factor that is applied, the beta that's applied. So there are variables to determining what the cash flow is. Often enough, discount can come out to be a range of values that could be applicable, and most of the time we get an answer within the range. But I think it's an important feature to bear in mind that there can be these distinctions, but at the same time, what is normally regarded as one valuation methodology for FEMA is, for the most part, accepted for income tax as well. So far as, or in fact, the other way around, that what is accepted for income tax is accepted for FEMA as well. So far as the arm's-length tax is concerned. But at the same time, the arm's-length tax is much more subject to dispute and much more subject to litigation in practice in income tax than it is. I think the other thing, finally, this one final point would be to say that if you were to borrow in foreign exchange, then you would have to benchmark in foreign exchange currency. You would have to keep that as a consideration. There are rulings to two effects. One is the rulings from the tribunals around saying that the all-in cost ceiling does not act as a proxy for the arm's-length rate. And the second, that if you borrow in a foreign currency, then your interest has to be benchmarked in that currency as opposed to the normal currency of, let's say, the all-in cost ceiling that might apply to either the US dollar or, for that matter, the time lending rate of the Reserve Bank or the State Bank of India, the base rate of the State Bank. I think the one other point to make is that income tax, like we spoke of, emanates from the treaty because transfer pricing is an economic legislation that touches two countries, and therefore an adjustment that is made in one country has an effect on the other country's production or income, and therefore you often go into a multilateral or a bilateral, in other words, a two-country approach to resolve a cross-border transfer pricing dispute. So with that, I find out, I'll just say that fiscal legislations and economic legislations both need to, there is no absolute harmonization, but there is the concept of arm's-length price in the context of related party transactions and in the case of but need customs, company law, income tax, and FEMA with these lenses to be able to look at pricing as one of the criticalities of any transaction.
Thank you, Suchint. I think 3 or 4 takeaways from this, from Suchint's introduction. whenever you see a profit and loss account, if there is an import transaction, you can rest assured that there is an interplay and valuation between customers and income tax. If you see an interest from a commercial borrowing, you can rest assured that there is an interplay between adequacy of interest, quantum of interest, if it is from the related party, constant, if it is from an unrelated party, from the government tax perspective. So if there is an interest in foreign exchange debited, you have a flag which is there for audit purposes. If you see external commercial borrowing, there is a flag which is there. If you see import, there is a flag which is there. If you see export, there is a flag which is there. All of these are subject to valuations under customs, income tax, or FEMA. And one more valuation which is important is FDI and ODI. Whenever there is a FDI transaction or ODI transaction, there is a valuation. And that valuation has to be at arm's length because many transactions we see, most of them end up becoming associated enterprise. So, valuation, arm's length, income from other sources, or income from business, or income from other capital gains. All these three aspects come into play. Thank you, Suchint, for that. And next, we have our friend and partner from Super, Aditya Narwekar. Aditya leads one of the Indian teams of PwC, and we would request him to share his experiences and FEMA in the transaction space. Thank you, Aditya.
Hi, good morning everyone, and thanks Vivek for those kind words. So as Vivek mentioned, I've been with PwC for around 15 years and been with the transaction tax and deals tax. And today I'll be covering some of the critical aspects of the aspects which are relevant from the transaction perspective. So as we know, and most of our speakers spoke about FERA. Now, I've seen both FERA and FEMA, and there is a sea change between FERA and FEMA. In FERA, whatever we did, and we could close our eyes and say, okay, there is an approval required. Because that was the time, I think probably, it was a need of an hour for the company that the foreign exchange had to be regulated. But when we moved into FEMA, from a transaction perspective, it actually helped. And honestly, the timeline, the nature of the transactions, it grew so much that people started exploring innovative ideas in the FEMA. But having said that, it is not like completely free. There are restrictions, there are some compliances which are still you need to comply with. But if you look at FERA, it's a big change from where we were, and where we are today. Some of the things which we come across very regularly in a deals kind of a scenario is very simple, like sector, right? Earlier days, even in FEMA, most of the sectors, as you all know, the FDI is categorized in different sectors, right? So most of the sectors at the time of FEMA introduction was kind of regulated. It was still under the government approval. And when I said most probably 90% of the sectors. But today, as we see, the proportion has changed. 90% of the sectors are under the automatic route, and are these few sectors which are very critical for maybe for the defense, for the security reasons, or maybe one of the sectors which is very critical for the Indian economy is the retail sector. That is little bit covered or rather governed by the government. Otherwise, most of the sectors are free and automatic. You don't have to go to any authority or any approval is not required for the purpose of investment. Now, coming to the retail sector, it's highly sensitive for Indian economy, and hence government was very reluctant to open up. But having said that, now if you look at the single brand retail, it's again open up. It is 100% in any of your client want to come into India with a single brand. You don't have to go to any government authority or RBI for the approval. But there are certain conditions, like you have to comply with the sourcing norms and those kind of conditions. But at the same time, you cannot get into a multi-brand retail. So even a $1 investment into a multi-brand sector requires an approval from the government. Say now you can ask, okay, what is metro cash and carry? It is a multi-brand, but it is not a retail, it is a B2B. So technically speaking, you and and I cannot go and buy unless we have a GST registration. But yes, we know practically on ground things are different. But technically speaking, it's a multi-brand wholesale trading. It's not a retail trading, and that's why they are allowed in the country. Any investment in a multi-brand retail above 51%, it will not be allowed. So you are allowed only up to 51%, but with the government approval. So any of your clients who want to come into India in a multi-brand sector, they have to have a government approval, even for $1 investment. Coming to the second aspect, which is very critical in any deal scenario, is the very recent development, press note number 3. As we all know, there are restrictions for investment from our neighboring countries, and one of the countries is the biggest investor, and we keep getting the inquiries as to how do we invest to China, right? So how do we get the investment from China? So as per the press note 3, again, not even a one share can be acquired by a company whose ultimate owner is a Chinese company, right? This is the law. But on ground, practically what we have seen is some of the AD bankers, as Chidanand also said, a lot of powers have been given to the AD bankers, and some of them are very knowledgeable and very active, and they will come forth and they give you the advice based on the RBI guidelines, which are publicly not available for any one of us. But there are certain internal guidelines which are given to the AD bankers by the AD bankers by RBI. On those basis, they come up with some kind of solution. So some of the AD bankers do take a position that if the investment is less than 10% from say China, it is still allowed. But technically speaking, if you say, if you come to any of the Big Four or anyone, probably the answer would be no. But then we can sit there and get some legal opinions and still go ahead. But that's a real practical problem, because in any transaction, what happens is you do not know who is the ultimate owner. And many times, what has happened is we have gone ahead, we have done all the documentation, and then finally we find out that it is from a country where the investment is restricted. Then it's a big challenge for us to come out of it. So it is very important to first ask and see who is the ultimate owner, so that if the approval is required, we can go to the government authority and take the approval. And similar thing is the sectors as well. So many times what happens is your client will come and say that, okay, I want to invest in this company, very simple, resident to non-resident share of transfer of shares. The company is into the software business, this, that, and all. But when what we do normally is we evaluate before getting into the documentation. We just do an evaluation phase where we see what is this business. Because 9 out of 10 times, the company will not be doing only one single line of business. They will have certain businesses, other businesses. For example, Axis Land. If it is an Indian promoter-driven company, they may have land in their company, or they may have some businesses like a small defense business. So what happens is that when you eventually get into the documentation stage, you find out that there are these businesses which are not fully automatic or fully 100% allowed. And then it is a very tricky situation to kind of say that, okay, now again you need to hive off some of the businesses from the existing company. Then it becomes like a major complex transaction to kind of implement. So it is very important to at the beginning to see that, okay, what are these sectors, what are these the countries from which the investments are coming. The third point is, as we know, no one wants to pay the consideration upfront, right? And all of us, like if you are buying $100 million or whatever is the amount, no one is willing to pay today upfront. They will always want to have certain kind of a condition to say that, okay, I will give you certain amount, maybe 1 year, 2 years, 3 years down the line, depending on whatever condition they may have commercially. In the FEMA, anything like this transaction would have required an approval from the Reserve Bank of India. Even in the FEMA regime, for some time there was no clarity on the deferred consideration part. So everyone, again, there is a kind of a rule that okay, if it is not explicitly given, then probably you should take an approval under the FEMA. So we don't go into an aggressive interpretation and legally because you never know what will happen in the future. So everyone took a call that deferred consideration may not work, and then RBI came up with a clarification that yes, deferred consideration can be explored because that was a kind of a requirement for all the deals transactions which were happening. What it says is you can defer the consideration up to 25% of your total consideration up to 18 months. Okay, so beyond 18 months or beyond 25% of the consideration, it is not possible. Then you have to go to the RBI for the approval. And what we have seen in some cases, in genuine cases, RBI has allowed, but you need to have a reasonable kind of a reasoning to say that okay, why we are saying it is more than 25% or why we are saying it is beyond 18 months. But having said that, okay, in a transaction, and this applies to both ways, like when a non-resident is buying the shares from a resident or when the resident is buying from the non-resident, it works both ways. And so far, a transaction between two non-residents, the deferred consideration is still, we believe that it is acceptable. There is no restriction in the deferred consideration. If it is a transaction between two non-residents, say one non-resident selling the shares of an Indian company or as a non-resident, there you can still have the deferred consideration mechanism without any limits as prescribed by the FEMA regulations. The fourth critical point is the valuation. I mean, even Suchint spoke. So the valuation methodology has been evolved, in the FEMA, I think in all the laws. Especially in the FEMA, they started with few valuation methodology, but finally, kind of they have kept it open to say that it is a internationally accepted valuation methodology. Right? Now, the challenge comes, many times the clients will come and ask, okay, can we have a book value? Is it not internationally accepted valuation methodology? Yes, it is, right? I mean, there is no doubt in that. But at the same time, because see, FEMA is not a standalone thing. Suchint will come and say, okay, it is not a related party. I mean, it's not at arm's length. Because typically, if you have a business, typically what you should do is a DCF method and not a net asset value method. So most of the time, only in few cases where the company is not operating, there is no business, you can still go ahead and probably convince the ED bankers to say that net asset value method is acceptable because you don't have a business to do the DCF value, right? But most of the time, the method which is accepted by the ED bankers is discounted cash flow. So far, we have not seen the ED bankers coming back and challenging the DCF itself. Okay, so they have not gone into okay, why this is the discounting rate, why this is the growth rate. That they have not yet done. But having said that, on the face of it, discounted cash flow, if you submit it with the ED banker, that should be accepted. The challenge comes when the transaction happens at a global level, right? The global level, say for example, say IBM is acquiring say XYZ. XYZ has something in India. They would have determined the price globally. They wouldn't have attributed or they wouldn't have calculated the value at an India level. But what happens is that many times you need to find few documents with ED bankers when there is a say business transfer, where there is a share transfer at an India level, which is driven by the global. So what do we do at that point in time? We have not done the valuation at the time the parties have agreed commercially the fair value of the business. So that becomes a challenge. So it is better to highlight that upfront that if there is something like this, if there is an India element in any global transaction, it is better to have that valuation upfront so that going forward when you have to file these documents, just not FEMA, but even with the income tax department or wherever you need to file, it becomes a challenge to kind of probably go against the global valuation because then it becomes a challenge because it may not add 1 plus 1 may not become 2 then. So it is very, very critical that if you are in a global transaction kind of a scenario to have or at least highlight that believe me, at least 7 out of 10 transactions, what we have seen is the client would not have filed the form FCTPR. Now, what has happened is everything is linked. When the transaction is actually happening and when you have to file form FCTRS. So, okay, basically FCTPR is when you issue the shares. Form FCTRS is when you transfer the shares between the resident and the non-resident. So when you go for a transaction, when there is a form that is FCTRS which needs to be filed, the AD banker in his record will see that there is no FCTPR which has been filed for the shares which are ready for the transfer. Trust me, 7 out of 10 times we've seen that the transaction getting delayed because of this. And typically what happens? Then what do you do? So luckily the FEMA has certain regulations which says that okay, you can regularize this by late filing, by paying late filing fees. But at the same time, this kind of impacts your transaction timeline. So it is very critical, and that's why most of the time the legal due diligence is involved, and they highlight all these non-compliances or the ones where the FEMA forms have not been filed, so that at least you have kind of a 3-4 months of timeline to regularize those non-compliances. And many times we have seen when we go for that late filing piece, the documentations will not be available. That is also one very, very critical aspect. And if that is the case, then we are in a big trouble, because the general assumption by RBI is that if you don't have documentation, it is presumed that you have not filed. Okay, RBI will not sit and search for you. They will presume that you have not filed. Okay, so then it becomes a bigger challenge to how do we get those documents and regularize it. So it's very critical that we are very thorough or 100% from a compliance side. Then coming to some of the aspects of how, as Chidanand also said, it is, I think after GST, FEMA is one regulation which gives you the update probably every year or every alternate day. So we are just talking about the deals here, but FEMA is quite wide. If you look at capital and the current account transactions, the notifications probably come every day. So you have to be, kind of, unfortunately, you need to know all those regulations, so that you are compliant with with FEMA whenever the transaction happens. So it becomes little critical to kind of know everything at the time it is happening. Another critical aspect is we have a concept in FEMA called as foreign-owned controlled company. I'm sure all of you know what is foreign-owned controlled company, wherein it's generally called as FOCC. It's basically a company which is owned by foreign shareholders, or it is managed and controlled by foreign shareholders. Basically, if your foreign shareholder holds more than 51% in Indian company, by default it becomes a FOCC, that is foreign owned controlled company. Other way around is, say for example, your foreign company holds say 48%, but they control the management, board and everything, then also it becomes a foreign owned controlled company. Under FEMA, foreign owned FOCC is considered to be a foreign company. So whatever activity FOCC does is as good as your foreign shareholder is doing in India. What that means is your pricing guideline, that is valuation, whatever compliances that the foreign company has to do in India, that same has to be done by the FOCC. Say for example, now FOCC wants to buy shares in India or another Indian company. Though it is if you look at the company law, it is between two Indian companies, like one Indian company buying the shares of another Indian company. But FEMA, it is not like that. It is one foreign company buying the shares of another foreign company. So you need to pay a fair value as per the FEMA guidelines. So another basic thumb rule in FEMA is that if you are paying out or the money is going out of the country, whatever valuation you determine is the maximum value. Okay, you cannot go beyond that. So for example, you determine the 100 rupees or $100 as the value of the shares of your company. And someone someone is or you are buying the shares from another company or foreign shareholder. You cannot pay more than 100 rupees or $100 as determined by the FEMA valuation. That is the maximum price. You can come down, but you cannot go. But the other way around, when the non-resident is buying, when the money is coming into India, whatever valuation is determined, whatever price is determined, is the lower price. So again, same example, the non-resident is buying the shares from your client who is a resident in India, and you determine 100 rupees as a share. He can always pay more. Okay, I mean, there is no restriction to go above that 100 rupees because that is the floor price. This same guideline applies even in the case of a FOCC, that is foreign owned control company. So many a times, we miss that those compliances when the FOCC is undertaking the transactions. Again, FOCC cannot take a loan, for buying the shares of an Indian company. So that is also very critical that we need to keep in mind. That many a times we get a query from our clients that, okay, I have this company, can I borrow and buy the shares of an Indian company? No, that is not possible. That is not allowed. FOCC, whenever they are buying shares of an Indian company or any company, they have to make certain compliances. So there's something called as Form D, that is direct investment, where it has to be filed. Again, if you don't file that, and whenever in future, if your client wants to sell this company, that would be a non-compliance, and we have to be very regularized. So that's one of the most critical, and many times we miss that compliance when the FOCC is buying the shares of the Indian company. Again, in the case of an FOCC, the deferred considerations still apply. You cannot have those even though it is between the two Indian companies, we still have to apply the deferred consideration formula or the 25% and the 18 months criteria for the FOCC in the case of acquisition options. Then comes the now these are all simple direct share transfers, right? Many times we have come across a scenario where company doesn't want to pay cash. Okay, say take an example, Indian company buying the shares of a foreign company, but they don't have cash. What do we do? Typical question is, can I issue my own shares? Yes, now it is allowed. Earlier it was not allowed. Again, we have to go for approval from CA, but the regulations have been relaxed. So if an Indian company buys the shares of a foreign company and you have to issue the shares to the shareholder of that foreign company, it is possible, but subject to certain compliances. Because what happens, if you look at it, it is both FDI and the ODI. Say for Indian company, when it is buying the shares of a foreign company, it's an ODI or Indian company. At the same time, Indian company is issuing its own shares. So that's an FDI for Indian company. So you have to comply with the guidelines. But having said that, this has created a lot of it has reduced the pressure on the Indian companies or the buying companies because there is no upfront cash outflow from the company. Because lot of times we feel this, and people are struggling to buy because they don't have cash. But this is a mechanism a lot of people use in day-to-day transactions, that they issue their own shares and buy the shares of another company. So that is completely allowed now. Coming to the ESOP structures, again, ESOP structures are very well valid today. It is clearly given by the FEMA guidelines that if the foreign company has an ESOP plan, and through the ESOP plan, if the Indian employees are getting the ESOP of the foreign company, it is completely it is allowed and there is no approval required. And this is relevant because most of the time in say promoter-driven company, there are kind of requirement where you cannot give cash, entirely cash, or you cannot give the shares of a foreign company to the promoter. In that case, we explore this ESOP kind of a structure wherein the promoter will get the ESOPs of the foreign company by becoming an employee, and at the same time getting the shares of the recently, maybe a year back, we also saw a very important change in the something called as round tripping structure. So if you all know, there is no mention of round tripping in the FEMA regulations. Basically, what it means is Indian company or Indian investor investing outside India, and that company again investing back into India, is typically was not looked at favorably by RBI. What RBI always assumed or thought is that the money is going out and the same money is coming in for buying the shares of an Indian company. And that was not, I mean, it was not given any regulation, but if RBI or someone picks up, it was not allowed. So last year, RBI came up with a guideline saying that yes, you will allow this for the genuine transaction and they will allow up to only 2 layers of the companies. So basically what it means is that Indian company can acquire a foreign company and the foreign company may have multiple chains, but foreign company can have only one Indian company below that. So basically when they say 2-layer structure, it is foreign company and Indian company. There can be multiple foreign companies holding that Indian company, but there has to be only one Indian company. So that kind of structures are now allowed by RBI. But the problem would be like typically what we see, who are the investors, individual investors. Now individual investors, as we know, do not have a bandwidth to invest in foreign companies unless it is an LRS, and LRS has only $250,000 limit. So what do we do? Like most of the promoters come and say, okay, we have this fund, so we want to invest outside India. How do we do that? So there are structures like then you have to get into an ODI. Basically, you form a company or a LLP or a partnership firm which has the network sufficient to invest into another foreign company. So that's again a change from what we saw in earlier days, that who all can invest in the foreign companies. Now any company who has a 400% net worth can invest freely into another foreign company, and then it can come down to Indian company. So that is kind of an allowed structure currently by the RBI. As I was mentioning on the share swap, now the share in these cases, a lot of times what happens is what we see is startups, right? Many a times the startup structure is you have the IPs outside India and the support, everything comes from India, and typically the value is attributable outside India because the IP is sitting outside. So typical question would be, how do we sell this, because this IP company would be typically held by the Indian promoters, or it will be a combination of Indian and the foreign promoters. So in those kind of scenarios, again, we have to be a little careful because typically these structures were created before the regulations relaxed the round tripping kind of a structure. And back point in time, a normal structure would have been gifting of shares, right? Like one promoter gifting the shares to another promoter who is non-resident and getting those shares as a gift. And which is, again, there's nothing written in FEMA about such kind of a transaction. But having said that, it was always a gray. It was not a black and white. There was always a gray. Like if you have received the shares by way of a gift, can I still go ahead and can that structure be kosher from the FEMA perspective? Having said that, yes, a lot of AD bankers have tested, or many of the legal counsels have tested, and now we've seen that going forward, many of the companies have implemented that transaction and have gone ahead. But now, if you want to implement those kind of a structure, it is better to invest through LRS or something, so that the structure is kind of kosher from the FEMA perspective, so that you don't get any questions at the time of the later sale of the shares of those companies. Another important aspect is now the inward merger, right? Like you would have seen a lot of companies, especially the startups, what they are trying to do is that they have started, so during COVID or before COVID, apparently it was US market was very attractive. So everyone created a structure where US holdco and India operating company. Yeah, right. We can note that I need to finish with this quick one. So now what has happened is, now the regulations are allowed the flip, I mean the structure where US or a Singapore holding Indian company can merge those companies into Indian company. Again, a lot of companies have implemented, they are implementing, it is there in the news. One good thing is now the FEMA regulations have kind of given, or at least given a kind of a roadmap as to what they can do in such kind of a scenario. Earlier it was completely, it was like a black hole. We didn't know what to do in such kind of a flip we need to do. But having said that, now the FEMA, at least from a FEMA angle, it is very clear you can do. But there are challenges from the tax side. So it is still may not be very efficient unless and until it is very commercially viable to flip the structure. So probably with that note, I will finish and maybe I will take the questions later. Thank you.
Thank you, Aditya. We are now at 11:30. We started 15 minutes late, so I request Lalith to help us with this overview of external cost borrowings, and then we'll have a quick 5 minutes update on practice survey from now, and 2 or 3 questions, and we need some portion into your tea break if all of you agree. And I will not be giving you a choice, just telling you. So we need 50 minutes into your Q&A, please. Lalith, thanks. Oh, by the way, Aditya kept talking about FOCC, foreign owned controlled company. Lalith represents a Karnataka owned and controlled company. They are accounting services from Myriad and proud Kannadigas, and they have recently won the FEMA award for MSME outstanding export performer from Karnataka in the accounting services. So, thank you, Aditya.
Thank you, Vivek, for the brief about our company and for giving us an opportunity. In fact, I have to thank you for one more thing, which has taken me back some 40 years and made me remember my college days. And you must be wondering why. See, with even 40 years, the demand for the back seat still continues. Anybody who came in early always preferred back seats, and people who came late were totally disappointed. I could see them, oh, my favorite seat is gone. And the institute members had to escort people forcibly and ask them to occupy the front seats. So, with time, a lot of things don't change. I think that is what human tendency is all about. Anyways, jokes apart, I think you all people have been already taken through technical sessions and you are just wanting a break from this. So I will not take much time. My session is the most easiest and I would thank Vivek for providing me that option. My session is basically to just bring forward to you the intricacies of what needs to be taken care when you are filling an ECB application. I'm sure you are all aware with the present trend of new funds coming into India and the need for setting up. Unfortunately, what is happening, most of the multinationals still have this fixed mindset that equity infusion may not be the right path. They still don't want to bring in money by equity route. They are always happy to give a loan. I don't know it's their mindset, but they are always willing to give it as a loan. Maybe they have their own reporting norms, so they are very comfortable giving a loan rather than infusing as an equity. So, as I said, my technical session will only cover the requirement of filling up the application and what care needs to be taken. Probably the ECB is such a vast topic. Or the office bearers can have a separate sessions, but still, please don't be disappointed because I have prepared a detailed presentation on ECB guidelines requirements and we will share it with you. So, in case any questions are there, feel free to reach out. My coordinates are there in the presentation. So, please feel free to get in touch and we'll be very happy to help you with that. Any clarification. So, I would not. Straight away, I'll start off with no, it's, I think presentation is not required. We have all learned and educated people here, chartered accountants, future chartered accountants, and veterans in our field. So I don't think the presentation will make any difference to you. They come here to hear me, and I think I should ensure that the message what I have come prepared for is communicated. So I will not touch more on ECB. What is ECB? I am sure you are all aware that it is a borrowing from an overseas company or a financial institution or a parent company or whatever. So that is given. There are foreign exchange regulations, Act 3 Acts to be specific, which are relevant for this. So these are all given, and these details you will find in my presentation. So straight away, and of course, there are a lot of advantages of dealing in this ECB because, for example, it is cheaper and it is a long term. Similarly, there are disadvantages, like you said. Any foreign exchange borrowing is subject to interest payout, and the biggest is exchange fluctuation loss. The normal trend is say 1 year for a short-term loan, which is allowed, but then it doesn't happen in reality. The loan, normally ECB is taken for a 5-year, and today the fluctuation in dollar, which we are seeing it after 5 years, we end up paying a huge amount. Of course, the option to convert that into equity is there, but then obviously it will be at that valuation at that exchange rate. So it has its disadvantages as well. So now, as I said, the documentation requirement for ECB is in multiple parts. The first part, and I'm assuming the steps relating to the draft loan agreement, which needs to be executed by the company with the organization or the borrower and the lender, is already vetted and approved by the bankers. Similarly, with the bank resolution, company needs to pass a resolution for availing the ECB. I'm sure, I assume that this compliance has been taken care. The board resolution has been shared with your authorized dealer and vetted. Because a lot of times we are seeing in practical world what happens is once a board resolution is passed, the bankers come back saying that no, this needs to be deleted, this needs to be inserted. So it's always advisable to get the loan agreement and the board resolution vetted by them. Okay? So let's move on to the practical aspects of what the application consists of. It is into 2-3 parts. The first part is basically there will be a covering letter, basically, where you which is addressed to Reserve Bank of India to your authorized dealer, and it says that please find include the following documents for your review and consideration for ECB loan. So the loan application primarily is the main form which I will come to this in detail as to what all is forming part of the loan application. Apart from the loan application, there is Annexure 1, which is mandatory, which needs to be filed. You need to, there is a summary sheet which needs to be certified by a company secretary or chartered accountant, apart from signature from the authorized signatory of the company. You have a board resolution copy which needs to be attached to the application. You need to attach the loan agreement, basically a copy of the loan agreement which has been executed between the borrower and the lender. Then normally see the requirement as per RBI is that once this resolution has been passed by the board to await the ECB, you need to submit the application within 7 days. And in reality, it never happens. It takes some time for getting the signatures and all. So RBI insists that there has to be a condonation letter attached with the application form. Otherwise, it may come back again for this. So ensure if the 7 days period is exceeded, you attach the condonation letter. There need not be any specific reason. You just say that due to certain technical reasons there was a delay, we request you to condone and consider application. Yeah, copy of list of directors and copy of certificate of incorporation memorandum article. And last but not the least, the complete shareholding pattern along with the ultimate beneficiary details, and you need to also ensure the KYC document of these companies are attached. KYC, the certificate of incorporation, giving the evidence of the company, registration and its address. These are all the things which need to be attached with the application, and if these are attached, I'm sure the application will be taken up and your ECB loan approved. Now coming to the detailed form, yes, there are certain declarations which you need to make in your application form. Now, this was the covering letter which I spoke. Now we come to the actual application form. The application form part 1 says that you need to make a declaration that all the provisions as mentioned under the Foreign Exchange Management Act have been complied with. The loan is actually being availed for the purpose which is approved, and it is meeting the norms which are required under the RBI regulations. This is the next is you need to confirm that the loan agreement which is executed between the buyer and the seller has the following clauses included, and it says first and foremost is amount of the loan. Now, loan again, though the RBI regulation says that it can be availed in foreign currency, but the most preferred currency today practically is US dollar. Of course, you can avail in GBP or Euro, but then there are certain companies which have been set in UAE or some other country. For there, what happens is these are pegged against US dollar. So the preference of your authorized dealer is always to have the loan in USD if possible. So this is something which you need to discuss with your authorized dealer and ensure the loan is available in that currency, and so that it gets approved. Purpose of the loan. Basically, as you are aware, the purpose of the loan is already defined in the ECB. I will not get into technical details of it. That has to be very clear. Tenure of the loan. This should be in line with what the guidelines are. For working capital today, you are allowed to avail ECB for even working capital requirements. The tenure is generally 5 years. Ensure that period is mentioned in the application. Otherwise, it will come back. Then you will have to talk about when you wish to draw down. So, a company may not want to draw down the entire ECB within one installment. They prefer to defer it. They may want some amount to be received, say immediately. Some they want after 3 months, some maybe 6 months. But the entire period should not exceed 1 year. Ensure the ECB arrangement should not exceed 1 year. Maximum period of availing should not exceed 1 year. Drawdown schedule. This is what I meant. Has to be mentioned. Interest rate. Now, interest rate is something which you need to be very sure of, because today there are two options. One is the fixed rate of interest, one is the flexible rate of interest. Now, earlier most of the applications were based on LIBOR, but today it is more on SOFR, which is your secured overnight financing rate, which is more prevalent with in ECB borrowing. Repayment schedule, final maturity date. We also need to mention about the charges, if any, apart from the interest rate. See, because RBI has clearly said all-in cost rate should not exceed a specific percentage, 350 basis points or 450 basis points as well. So any other cost which is there apart from your interest should be definitely mentioned in the application. Commitment charges, if any, and if there is any security or guarantee which is being provided for availing this loan. This is what forms part of the application. Now coming to the contents of the next part is, you should also in your application clearly mention for what this loan is being paid, and you need to give a split up. What is the amount for plant and machinery, what is the amount for equipment, and what is the amount for working capital. This should be mentioned in respective currency. Okay. Declaration that the company has not violated any of the ECB policy. I'm sorry, please bear with the other 5 minutes, I'll just finish it off. Declaration that the company has complied with all ECB policies. Also that they have not defaulted on any of the violations of RBI regulations. And if there has been any ECB loan availed in the past, they have complied with that in total. Otherwise, if there have been any non-compliance, your subsequent ECB application will be rejected. This means if can you avail multiple ECBs? Yes, you can do that. So that is one. Yeah. The next component probably would be declaration of ECB process for the purpose which has been used. There are certain purposes only for which it can be used. We need to declare that this is the loan to avail and utilized for that purpose itself. Yes, that is all the part of application. Coming to the annexure one. See, annexure one is the main form, and the format of this is available on ECB on RBI website. This is the form which contains the complete details of the loan which you avail, and it is divided into about 6 parts. Part that talks about the borrower details. You need to clearly give which is the name of the company, who is the person who is authorized, what is his contact number, email ID, all these details need to be mentioned in this annexure one. Second is the lender details. Similarly, the lender details need to mention in the application in clarity, giving complete details about the company, the principal person who is responsible, his contact number, all that. Third would be the loan details. Basically, this is the most crucial section of loan in the annexure one, and it talks about the loan agreement date, the effective date of loan, last date of disbursement, maturity date, currency, hedging, guarantor, security purpose, interest rate, schedule, etc. This is something which you need to be very careful while filling. Ensure that you prepare a draft, get it vetted by your banker before you submit the application. Because some mistake may be committed because of interpretation. Ensure that this is taken care. The next part would be charges, and the last part would be details of ECB availed if any. Yes. After this is the part of the application. It needs to be signed by the authorized signatory of the company, whose name has to be captured in the resolution which you pass. The next part would be the summary sheet. Now, summary sheet is something which needs to be certified by an external professional. Of course, it is prepared by the company, signed off by the authorized signatory, but it needs to be certified. This will contain details of the end confirmation about the end use of the funds, the average maturity period, the cost factors, confirmation the ECB is used for working capital or for the purpose which is meant, then security details and any other important aspects related to ECB. As I said, it needs to be signed off by the company and also by a professional company secretary or chartered accountant. This is a mandatory and there is no compromise here. Yeah, this is the last part. Once your application, along with your annexures, see, I have spoken only in respect of a working capital application. If it is for setting up a new plant or something, the complete project report has to be annexed with the application. It has to be. So, if it is a working capital, then no major projections or anything is required. But if it is for setting up a new plant or a new project where it is meant for long period, a project report is mandatory, which will clearly give the term of the loan. And remember one thing: any application to RBI must ensure that the loan can be repaid within the specified period. So that means the company should be able to generate surplus, using which it is in a position to repay the loan. Otherwise, it will definitely not get generated. You cannot say we'll extend the loan or we'll convert it into equity at the time of filing. So ensure this is taken care of. Once this application is filed, what happens is you get an LRN number. Your banker will forward it to RBI, and the time period for getting the approval once the application is submitted by your banker is 5 days. So you should hear back from them within the 5 days of approval, or if there is any questions raised by any officer in the RBI. Generally, if the application is containing all the information and it is vetted by your banker, there is no such problem. We have not seen any issue at all. The applications are getting approved. Once the application is issued, you will get a formal letter and you will get a loan registration number. Now, this loan registration number is mandatory to get all your funds, because every correspondence related with this ECB should have the LRN number mentioned. Okay. Now, when the LRN number is issued, RBI requests you to file for ECB2, and this form will have to be filed from the date the loan agreement has been entered into. It is not in the future date. So suppose the loan agreement has been executed in January and you get the loan sanction say in March, you will have to file your ECB for the past month also, and within 7 days of you receiving the approval. In future, every month you have to file the ECB2 within 7 days of the month. Now, even you may ask question, what am I required to file ECB2 even if I have not received any money or interest? Yes, you will have to file a nil return, and this ECB2 is the form which needs to be certified by a company secretary or a chartered company, and he needs to mention his UBN number. The details of this ECB2 is available in the presentation. I would not want to get more into this. So this is a brief about the application and the post-approval process, what needs to be followed about the ECB application. And as I said, probably we can have a full-fledged session on ECB if there are people. And that's all from my side for this. And as we already exceeded probably questions, Vivek will definitely insist on some questions. And if there are any specific questions, probably you can discuss it offline during the tea break or the lunch break. And please do not hesitate to write to the coordinates which are provided in the application in case you have any doubt. We will be very happy to do. Thank you very much. Thank you for the patient hearing.
Thank you. How many members are practicing chartered accountants? Would you want a quick 5-minute overview of what to read in FEMA? What to read? Okay. This is my 27th year of practice in FEMA. So I've been practicing FEMA since my articles days. So I can tell you quickly what are the 5 or 6 things you need to read in FEMA so that it helps you with your practice. One is FEMA Act, Section 2356, enough. Section 2356, enough. Don't waste too much time on the Act. Rules, current account transaction rules and the compounding rules. These 2 rules, enough. So don't bother reading too much more. In regulations, OI regulations and OI rules, I don't think you need to worry too much about any other provision on rules and regulations. But what you do worry about is master directions. Master direction, import of goods and services, it doesn't come under any rules or regulation, but it is under current account transaction coming from RBI. So, master direction on import of goods and services, one. Second, master direction on export of goods and services. Third, compounding. Why I say compounding is, there is a sunset clause. I'm not able to figure out the exact provision. There is a sunset clause coming up 3 years from the implementation of new compounding rules in 2022 or 2024. So there is a sunset clause for all historical offences. So look at that and master compounding rules. Then OI regulations has a master direction for overseas investment. The master direction for overseas investment, master direction for foreign direct investment, master direction for external commercial borrowings. If you are thorough with these 5 master directions, or even if you manage to glance through, 99% of your questions will be answered from a corporate perspective. From an individual perspective, there is only one master direction. FEMA deposit regulations and master direction on deposits. NRI, OCI, NRO account, NRE account, FCNR account, all these credits which come from individuals are all covered under this master direction and deposits. Immovable property, if you have some clients who are specific about dealing in commercial properties, NRIs, OCIs, immovable property regulation in India. NRIs and OCIs deal in commercial property, but residential they restricted to only two. These come out from the deposit regulations. So if you are basically this, whatever I said, these 5 or 7 or 8 aspects, if you are managing to flip through, your practice in FEMA is covered. So it's not complex. There are 2 books like this, which is FEMA the actual contents of FEMA, Act, rules, regulations are encompassing two big fat books like this, but just to scare you. Be smart, read only those things which help you in daily practice. Otherwise, you get lost. This is intimidating. FEMA is intimidating. Unlike income tax act, there are 298 sections, and there are certain aspects which you can search easily. FEMA is difficult to search. Aspects of FEMA is very difficult to search, but keep these transaction specific regulations in mind, and you find the answer. Don't go to the act, don't go to rules unless it's absolutely essential. The master direction gives the answers 99% of the time. Okay, so that is a quick overview of how to read FEMA. And practice. Whenever there is an inward remittance, prepare for it. Don't let an inward remittance come before homework is done. Be it ECB, be it FDI, be it simple things like receipt of export, consulting services. We do consulting for an external. Don't receive anything unless you are sure what you are receiving, and the bank is intimated in advance when it's incoming. Be careful. India is the only country in the world where there is restriction on incoming. Every country is happy with incoming dollar. Here, even if there is incoming, there is banks have a problem for compliance, and there are times when money go back also, right? So incoming is like a missile which is coming towards you. You should have your iron dome ready before incoming comes. Outgoing is easier because it goes to the bank. So compliance checklist is done by the bank. You are outsourced to the bank. Your compliance starts after the outgoing goes. So incoming, be careful. Outgoing, bank does the homework. Yeah. So if there are any quick 2 or 3 questions, you can ask the panelists. Why I say ask the panelists? It's very difficult to assemble a panel like this with actual practical experience in foreign exchange. So if you have any questions, make use of this. Be selfish. Ask those questions. If there are no questions, there are questions.
What's the recent trend of
What is the recent trend of RBI permitting external commercial borrowing for some sale or some acquisition?
So, what we have seen is ECBs are not allowed for buying shares, but for acquisition of business, we have taken a view that it is possible and it has been blessed. So, there is no problem for taking the loan for acquiring the business.
When there's a moratorium on the interest, how does RBI do it? Do you look at the volume cap ceiling on a year-on-year basis, or the year in which interest is being limited? Do you look at the volume cap ceiling at that point?
It's year-on-year basis. That's what we have seen in the past. But honestly, the AD matters have not come back. But we have in the past advised on a year-on-year basis.
When you say year-on-year basis, does it mean that in the year of moratorium I can be higher than the volume cap ceiling as long as when it's spread over?
Yeah. But again, I mean, AD matters were okay with that unless something. But we always check with the AD matter before allow that.
Yes, sir.
So I have a question. We've got a person who is a non-resident and he had assets earlier, correct? Under the income tax also you are required to report foreign assets. And the question is really, if they dispose of the assets now, being a resident, are they required to repatriate it back to India, or they can hold it back in the foreign country? What is the regulation around that?
If he has acquired the asset whenever the person is dead outside India, he need not repatriate it back. He can hold it there itself in the bank account there. That is not in section 6.4 of the Foreign Exchange Law. 6.4. It provides for holding the asset there. The only thing is reporting requirement will always be there under income tax.
No. This is a situation, for example, he is investing in shares, correct? So they keep on rotating. So while he was there, he acquired shares earlier. Now he is selling it, purchasing, purchasing. So now he's a resident. So in that case, how does it apply? Correct? It's a brokerage.
It's clear. One, your residential status determines your ability to hold assets outside India or government. Once you become a person resident in India, your residential status in India determines the future acquisitions. But 6.4 exempts holding of assets when you held a share, for example, when you are non-resident, you hold a share, transact in the share. But the second transaction which you entail, you do as a person resident in India, even at OPI and ODI rules, you have 90-day time limit to reinvest. If you open bank account, and within 90 days you can reinvest under realization repatriation regulation. If you don't do it within 90 days, it is required to be repatriated back to India. 91st day you have to repatriate. That's all. So the first transaction, you have the benefit of being a holder of asset as a non-resident. The second transaction, your status changes in India. The second transaction is a resident doing a transaction. Realization repatriation regulations apply. 90-day time limit. You can reinvest. No, you can reinvest or you can
Not coming.
So there's a Indian company which has a foreign holding company. When the structure was created, the promoter of the foreign holding company was an Indian resident. But now for this financial year, he's become a foreign resident. So is there any compliance that is required when he's turned a foreign resident at this point? And we are intending to transfer the share of the foreign holding company in the next coming year.
Right, you see, I understand this right. There's a promoter who's a resident Indian who owns a foreign company.
There is an Indian company, it has a foreign holding company. The promoter of both the companies is an Indian resident.
Okay.
When the structure was created in 2017, the promoter was an Indian resident.
And he created a foreign company and had a domestic holding company.
Yeah, he had a domestic holding company.
So that itself is a challenge. So if an individual holds a foreign asset or a foreign company, that company under Schedule 5 earlier and now Schedule 3 of the OI rules cannot hold a domestic subsidiary for individual other. So now going forward, this non-residential status may help him, but the original offense has to come out. So my request is don't disclose the name of the client. Let's go forward. Right?
Sir, I have another question.
I think sir has one or two solutions for you.
Was it prior to 2030 or after that?
After 2017.
After 2030 also it was not early, now it is allowed on a genuine situation, but as sir said, my view was it could not have been done, so keep it done. Once he goes outside the country, probably get to customer. Because he is a person, there also there is a catch in section 6.5. 6.5 there is a difficulty because once you are a person resident in India and you have done anything, being a person resident in India, because your residential status has changed, this investment would not practically change. The structure of the investment will not change. It remains the same. You can still hold that foreign investment, but the difficulty is you are not permitted to hold that foreign investment. The violation still continues even if you become the person resident of India to 6.5.
So my advice to you, I've done this before, regularize offense. RBI regularize offense. They will give some conditions and give some time limits. Regularize offense. And they will ask you to compound the matter. It should be smart. Because there are large amount of they will. Take another question, sir. Yes.
One of our client exported, the machine is done in testing. Later on, example, there is a invoice value is 20 lakh rupees. The testing is not fulfilled. Then later on discuss that instead of 20 lakhs, they come down to 10 lakh. How can you arrange that difference, the 10 lakh receivable in our books, and what is the consequences? As per the FEMA Act, once it is exported, we have to receive the foreign exchange within 15 months from the date of export.
Okay, quickly. If you are an exporter, your obligation to receive full value consideration. So you are saying you sent it for testing, which is job.
No, sir.
No.
We sent it for export.
Export, okay.
The importer done the testing.
Oh. So there is a rejection. Or reduction in value of export.
Yes, yes.
Okay. So one is, have you received the money on time? If not, for me exchange to for extension of time. Step one. If you are not, and if you have reduction in value, then you have applied the 80 back for reduction in value of 25% taken to about 25% taken to the
But actually transaction is happening 2021.
transaction can happen whenever. They'll first ask you to do an extension of receivable.
Okay.
EST will ask you to file and get the permission for extension of the time limit.
beyond 25%.
There's a new website called Pravaha portal, PRAVAAH portal. My request is put it through the portal, it's faster. Don't go through the email first. Go through Pravaha portal. That's what Sir is also advising.
So we hear from Suchint in the next session and further to Vivek at the last session. Thanks for the wonderful session. We're great for present momentum and